Ladies and gentlemen, hi, welcome to lawcaseuk.com, where today I'm going to be analysing the 2016 Court of Appeal decision in the case of the Crown against Evans. Sometimes you see this case referred to as the Crown against Chedwin Evans. It's a particularly well-known case because Ched Evans is a professional footballer and it attracted a lot of media interest once he was charged with the rape and when he was convicted of rape in 2012 and in the years that followed up to his appeal in 2016, which is where we're focusing today. The case is of legal interest for us because it shows us how the courts address the admissibility of a complainant's sexual history, particularly in this particular type of case. And in reaching its decision on these facts, the Court of Appeal in 2016 relied quite heavily on the 2001 House of Lords decision in the case of Crown against A number 2, which is a case I've also analysed on this website. If you want to know the full picture, you probably should look at A first and then come and have a look at the case of Evans thereafter. But for now, what I'm going to do is continue with Evans and begin, of course, with the facts. Now, Evans had been out on the town on the night in question with a fellow professional footballer. His friend had met a woman who he took back to his hotel room. They had sex. They were joined by Evans. Evans took over and had sex with the woman himself. On waking the next day, the woman had lost her handbag. She couldn't recall what had happened, and the police become aware and they speak to Evans and the friend. And Evans and the friend are frank in the sense that they provide the only evidence against themselves that intercourse actually took place. Now, the Crown decided to mount a prosecution on the basis that the complainant was incapable of consenting to intercourse on that occasion. So consent becomes a key issue in the case, but of course also running alongside is the possibility of a reasonable belief in consent, even if she hadn't actually consented. But in this case, it's largely, on the Crown's case, one where she is incapable of consenting. And at trial, the friend is acquitted and Evans is convicted. Now, Evans mounts 2 unsuccessful appeals, but in 2016, the case is referred back to the Court of Appeal by the Criminal Cases Review Commission. And it does this on the basis that fresh evidence has become available that wasn't available at the first trial. Now, the Court of Appeal are deciding whether to grant this appeal that's been referred to them by the Commission. And they have 3 questions to decide. Firstly, whether that new evidence is credible. Secondly, whether there's a reasonable explanation for not adducing it at the initial trial. And finally, whether it would afford a ground of appeal. And I'm only going to address really the last of these 3 questions. That's whether it would form a ground of appeal. Because the fresh evidence is evidence of previous sexual history, and it would only provide the basis of a ground of appeal if that evidence was admissible under one of the statutory gateways within Section 41 of the Youth Justice and Criminal Evidence Act. And it is this framework in that statute that governs the admissibility of this type of evidence. So let's take a look at the evidence itself and see what it was. The new evidence came from 2 men, and one of whom was supported in some way in part by his mother. So there were potentially 3 witnesses available, but it's really about what these two men say. Now, the first witness was a Mr. Owens, and he stated that on 3 occasions before the night of the alleged rape, he had been approached by the complainant at the end of a night out and asked if she could go home with him. On each occasion, they went back to his place and they had foreplay but didn't have intercourse. But each morning, she could not recall what happened, and she asked him what had happened the night before. Now, in addition to this, in the weeks after the alleged rape, the complainant approached Owens again in similar circumstances, but this time intercourse did take place. And in particular, and this is important, Owens said that the complainant shouted for him to go harder and she asked him to change positions so that he was able to penetrate her from behind. Now, that's his evidence. The second witness is Stephen Hughes, and he stated that he met the complainant over Facebook. They began a sexual relationship, which at times involved her calling him up when she was drunk at the end of the evening. He explained that this included her then, well, they would have sex, and what would happen was, at times, this would include her being on all fours and encouraging him to go harder. Now, there is, of course, some factual similarity between the accounts that these two are putting forward and what Ched Evans said had happened. He described similar wording and similar sexual position, and the fact that the complainant was taking the lead on the night that he was involved. So, that evidence, let's assume that they're over the first two hurdles of credibility and reasons why it wasn't adduced at the first trial. Is it likely to be admissible? Well, the admissibility, as I say, is governed by Section 41, and this provides 4 gateways through which a judge could allow previous sexual history to get into the courtroom. The judge has to give leave. It's not automatic in any case. And the other test that the judge has to apply, as well as the gateways, is the judge should only grant leave where refusal to grant leave might render any conclusion that's reached an unsafe conclusion. Now, if we look at the gateways, one of the gateways is that the evidence might be relevant to an issue other than consent. So the issue in the case is not consent. For example, if the defendant says, yes, I agree she didn't consent, but if you look at the evidence, I had a reasonable belief in consent, and that's part of the mens rea in the offence of rape. Now, in this case, that was of peripheral relevance. Although this gateway was raised by the Criminal Cases Review Commission, counsel for Evans at the hearing focused almost entirely on the next gateway that I'm going to come to. But that gateway of it's not an issue of consent, an example being reasonable belief in consent, is a gateway that has some relevance in the case, even though counsel largely addressed the main gateway, which I'm going to call similarity of act, because he focused almost entirely on this. And this is the gateway under Section 41(3)(c). And here the judge can grant leave to adduce the sexual history evidence if it is so similar to the event under consideration that it cannot be explained by coincidence. So that's the new test. For those of you that remember similar fact evidence, the court did explore whether the similarity needed to be so strikingly similar, but they discounted that as being the test, because if Parliament had wanted to include that degree of, or high degree of similarity, it would have used those words, and it didn't. So in this case, the defence had to indicate that this evidence was both relevant to an issue, which in this case was consent, and that it satisfied the similarity test. And when Lady Justice Hallett was looking at these two aspects of the two parts of a test, she found help in the speech of Lord Clyde from that 2001 case of A, where he said this: "It is only a similarity that is required, not an identity. Further, the similarity must be such as cannot reasonably be explained as a coincidence. To my mind, that does not necessitate that the similarity has to be in some rare or bizarre conduct. So long as the particular factor goes beyond the realm of what could reasonably be explained as a coincidence, it should suffice. Something about the sexual behaviour of the complainant on each of the occasions, such as something said or done by him or her, which is not so unremarkable as to be reasonably explained as a coincidence, has to be found." And so this led the court to reject the argument that the prosecution was making, that was saying there's nothing unusual in the behaviour, so it ought to be excluded. But the court said that it was not about it being bizarre or unusual, it was just about it being arguably sufficiently similar under section 41(3)(c. And then they added and under section 41(3)(a), which is where the issue is not consent, and it could be, for example, a defendant's suggestion of reasonable belief. So it was the court themselves that largely brought back in that suggestion for the Criminal Cases Review Commission. So they decided that it was sufficiently similar under 41(3)(c) and also could be potentially admitted under the gateway where consent is not the issue. Now, one thing that's really important to point out here compared to the 2001 case of A was that here the court reached its conclusion using ordinary methods of statutory interpretation. It didn't feel the need to read down the statute under section 3 of the Human Rights Act as the House of Lords did in A. Okay, so there's a fundamental difference in the way the courts dealt with the framework under section 41 in the two cases. In A, they felt that unless they read this section down, it could interfere with the defendant's right to a fair trial. Here, they felt that they could provide a fair trial within the wording of the statute based on normal interpretation. And the court was clear of this up until the point at the very end they just made this statement, and I'm just not entirely sure why they did, because they then said the requirements of section 41 must give way, as was held in A number 2, to the requirements of a fair trial. Relevant and admissible evidence cannot be excluded. So I'm just not sure why they made that mention about section 41 having to give way, because in this case it didn't seem like it needed to give way. The new material, as far as the court was concerned, was similar enough that it fitted through one or two of the four gateways. Now, accordingly, a retrial was ordered. The previous sexual history evidence was heard at that retrial, and the defendant was acquitted. Now, in terms of my comment, the court did say this was a rare case, although, of course, the prosecution's argument was that the behaviour wasn't very similar, so that there's nothing rare about the case, but the Court of Appeal did dismiss that. But the Court of Appeal said they reached their decision with some hesitation. They thought it was a rare case. And if we were being technical about it, of course, when we look at A, one of the things that the courts and Parliament have tried to do with the legislation is to avoid the twin myths. And the twin myths being that because a complainant is promiscuous or has a sexual history, that they are more likely to consent or less worthy of belief. But in this case, it could be said that to some extent the twin myths didn't arise, because here it wasn't a suggestion that she was lying about consent. What happened here, she just couldn't remember, and if you remember the case prosecuted on the basis, the Crown prosecuted on the basis she was incapable. So there was a technical argument, of course, to say that we weren't actually attacking her credibility in terms of whether she was telling a lie. It was accepted that she couldn't believe. However, if we look at the wider interest that Section 41 is trying to protect, it is certain, particularly because she went through giving her evidence a couple of times, because of the profile of the case, because of the fact that her identity was linked onto the internet and quite widely known, she will have suffered quite a degree of humiliation, one imagines, and also because the case was so widely known. One of the other purposes of rape shield legislation, like Section 41, is to prevent others from being discouraged from coming forward and reporting offences and then sticking with the prosecution of those offences. So in that sense, it may be that that purpose is not necessarily achieved in this case. But, of course, on the other side, there is always this crucial requirement under the Human Rights Act, under the European Convention of Human Rights, that the defendant has a fair trial. And in the case of A and in the case of Evans, that's what the courts were seeking to achieve, and they give us insight as to when this type of evidence will need to be admitted in order to ensure that the defendant has that fair trial. Thank you.